Good morning. Are you Renacia Segura?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Segura, in cause number 231869, I have a motion to revoke your community supervision. Shows that you were placed on probation July 29th of 2024 for the offense of theft of property with previous convictions, and that was a 2-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense of theft in aggregate amount January 29th, 2025 in Harris County, Texas. And is that true or not true?
True.
Count 2 alleges that you failed to avoid persons or places of disreputable or harmful character, and that you were at a location, you were arrested at a place where a crime had been committed with individuals who had previously been convicted of crimes. And is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And because they're actually true?
Yes, ma'am.
Give me a minute here.
Judge, I'd reviewed some of the Harris County offense material. She was essentially an accomplice while other people were committing theft in this instance.
I'm going to real quick look back at the pre-sentence report to see that all that the criminal, how many we've got.
A lot, and I won't say it.
Oh, yeah, no, I'm not accepting this. My notes, I sent you to ISF already. And my note says it was a cap of 15 months at that time. And I wrote on here that you deserved the whole 15 months. And it's like Mr. Lewis was your attorney at that time. And he and Ms. Holmes are both doing quite the job for you. But 8 months with 7 felony convictions for theft, 5 more arrests, plus this one, and now you've been arrested again, is not something I'm going to accept. Absolutely nothing less than the 15 months that was the cap in the first place. So it's either something like that, or it's an MTRP. I don't have to, y'all go talk about it. I'm deleting the paperwork. All right, go back with the bailiff. If y'all come up with something today, then that's fine. If not, we'll, but I deleted it. You'll need to redo something.
I'll say I told you so when I get down the offer. Because I have a note on my file that I argued for the full 15.
Well, then I don't, then why? Then throw it back in my face.
Well, I didn't want to on this one.
Well, it deserved it though.
They gave her like 30 days time served.
But that's Harris County. They give 30 days time served on aggravated robberies.
They do like 45.
I mean,
They do 45.
that doesn't count. That's not,
They do 45.
absolutely, when there's so.
Today's courtroom hearing begins with a defendant who appears ready to accept responsibility. But within minutes, the entire direction of the case changes when the judge takes a closer look at her criminal record. Renacia Segura enters court already serving a 5-year probation sentence stemming from a felony theft conviction. As the hearing begins, she admits to violating the conditions of that probation. One violation involves a new theft-related offense in another county, while another stems from associating with individuals connected to criminal activity. At first, the case seems straightforward. The defendant openly admits the violations, and both sides appear prepared to move forward under a negotiated agreement. But then the judge pauses to review the defendant's history. What follows is the moment that completely changes the hearing. As the court examines the pre-sentence records, a lengthy criminal history begins to emerge. Multiple theft convictions, numerous arrests, and previous probation issues paint a picture of someone who has repeatedly found herself back in the criminal justice system despite receiving opportunities to avoid incarceration. The judge quickly becomes concerned that the proposed agreement fails to reflect the seriousness of the defendant's record. According to the court, this is not an isolated mistake but part of a continuing pattern of behavior that is stretched across multiple cases and several years. When the attorneys present a recommendation involving a significantly reduced sentence, the judge immediately pushes back. The court notes that previous chances have already been given, including probation and earlier alternatives to prison. Yet despite those opportunities, the defendant has once again returned to court facing new allegations. The judge makes it clear that the proposed deal is unacceptable. Instead of approving the agreement, the court reminds everyone that an earlier violation had already resulted in a sente.